All right, it's time now for our legal lowdown with Attwood Marshall Lawyers. Today we're talking about something that can be close to home for many Queensland families, especially if you live in a rural or remote area. Families who own a farm or a business and passing it on to the next generation isn't always straightforward. Maybe one child has worked in the business for years while others have taken a different path. What happens when it comes time to divide the estate, and how is the family farm treated? There have been cases recently played out in the media, haven't they, involving multi-million-dollar farm properties and family disputes. So today we're unpacking how these situations arise and what the law says. How can they be avoided? We're joined by Estate Litigation Senior Associate Duncan MacDougall from Attwood Marshall Lawyers. Duncan, does this come up a lot where people are divvying up their estates, like farm estates?
Yeah, surprisingly, it's a larger estate than what you realize as well, because it consists of so many different things. So you've got the house, the farm equipment, if they're a large grain farm, seed, chemical, fertilizer, horses, you name it. So it's often a very emotional charged asset. It's often generational. There's a lot of identity that goes along through it, and it's not easily divisible in most cases.
And I guess sometimes I think about my family's business. We all worked at my dad's restaurant at one time or another, and for several years. It was my first job before I was told to go and get a real job because I thought I knew everything. So I started working in retail at 16 as well. But it is one of those things where if you've got one child that decides to follow the family business, and then you've got other kids or other relatives that are like not interested in it at all, and then when it comes time to divvying it up, is it just automatically assumed that the child or whoever went into the family business and kept that farm operating or kept that business going should be entitled to it or more of it?
Yeah, well, there's clearly that expectation from them that they ought to be getting something, provided that there's maybe some sort of reduced income or personal sacrifices by maintaining the farm. But in my own personal situation, I grew up on a very large family grain farm back in Canada.
Really?
I was the one who decided to jump ship to the other side of the world to pursue a law degree.
Yeah.
But and that's kind of how I got into the estate world is seeing how it passed down from my grandparents to my father, who's a sibling of around 8. So
wow.
It's a very
so this is close to home. So then what happened?
Yeah.
Obviously, the law is different in Canada to here. But what happens there when there's 8 children to divide it up with? What happens there?
Yeah, well, there's other substantial assets there, and obviously Dad took control of the farm and he's run it and built it to what it is today.
Wow.
So obviously there's transfer of land and property and equipment and everything else, but other assets such as bank accounts, shares, other things like that. In that estate planning process is to make sure that at least all the other children are equally provided for, or at least try to have an equal provision to all of them to avoid any of those risks of claims, etc.
I guess because the assumption is that, okay, well, if it's all going to be left to you, that's fine, and we have shares, do you have to then buy the rest of those shares out? Or what happens there?
Yeah, it's a difficult position, especially when there's all these expectations, especially from ones where, okay, well, there's these things where people in their estate planning say, oh, the kids will sort it out. They'll deal with it. No problem.
No, they won't.
Or there's these comments where it's like, oh, don't worry, it'll be an equal distribution. Don't worry about it. But in reality, there's maybe these ongoing promises that aren't properly documented, and all these expectations are relying on certain promises. When you see a document or a will at the end of the day, it doesn't accurately reflect what you've been promised during the course of their lifetime.
Joining me in studio right now, as he does every Wednesday from Attwood Marshall Lawyers, is Estate Litigation Senior Associate Duncan MacDougall. If you have a question for Duncan in regards to perhaps a matter like this is close to home for you as well, or if you've just got a general question that Duncan can help answer for you when it comes to, a dispute with an estate or anything to do with your wills, you can give us a call, 133 882, or of course you can text as well, 0499 880 882. Duncan is here standing by to take your call, to try and answer your question. This is fascinating to me about farms specifically, but also, businesses and things that make sense. If it's a business that's been passed on generationally, things would be a bit more complicated, more complex. Seems like there's a lot more red tape these days.
Yeah, there could be a lot of different things, like especially if it's operating as a business, some different trust structures that'll have to be taken into account as well. Who's going to be taking control? of those trusts if you were to pass away as well. Have the trust deeds been reviewed? I see this come up all the time where there's always these assumptions about what's actually going to be forming part of the estate and what's not. So if things are like non-estate assets, such as jointly owned property, provided maybe they got a new spouse, they married, there's now a joint property there, it'll automatically pass to her through the right of survivorship. Where again, kids in that situation may be left out. Relying on something that was promised.
Or like, I think of, I don't know why. And Ash, our in-studio extraordinaire, will say it's because you watched a lot of movie on TV as a kid. But my point of reference is The Lion King and Mufasa and Simba on the cliff face saying everything the light touches will be yours.
Yep.
So that whole idea is everything here will be yours one day.
Yep.
That's all very well and good in a very poignant moment in a Disney movie, but also in your life. But it means nothing if it's not written down in paper and you've got siblings. It happened just recently. There's a dispute in New South Wales, I know, where there was a multi-million-dollar farm in dispute between siblings. Can you give us a little sort of run through what happened in that particular case?
Yeah, that was a matter of bushel where you've had I think it was around that $20 million mark, so it was quite substantial. But again, there was this classic example, three different siblings, two of them left the farm, pursued their own careers, their own ways in life. There was some allegations of estrangement and otherwise, but there was one child who came and worked on the farm and received the substantial benefit at the end of the day under the will. The other two brought specific claims on the basis that, well, Dad promised me this, Dad promised me that. Don't worry, there's going to be a fair and equal distribution between all three of you, which I think under that circumstance, there was about $600,000 in a $20 million estate is pennies. So when you're talking about these sort of sums, there in those sort of applications, it went down a long list of things that the court generally considers in these sorts of claims. It's not a one size fits all. So generally, they'll look at who contributed what, the size of the estate, can they actually demonstrate need for further provision? So it's not yes, there's this moral obligation that a deceased person should provide equally between all three.
Just because you're related doesn't mean necessarily that you're, entitled.
Absolutely, yeah. But you got to look at the deceased intentions as well. What were their intentions? And you have a document here purporting to only benefit one person who's clearly put all the effort into maintaining the farm and getting it to where it is today. So in that instance, I think one of them ended up with a further provision, whereas the other one couldn't demonstrate that need or any sort of other contributions.
It is interesting to me when this sort of happens that a dispute would arise, and that is there ever a situation where a court would find someone's will to be unfair, even though they expressly wrote it down that's what they wanted? Yeah,
there's this all again coming down to that moral obligation to provide equally between, or to provide to a spouse, to provide to children. But the instance of fairness there's this dispute about, okay, well, what is fair? Rather than fairness, it's about what's adequate provision. And that's going to come down to a number of different circumstances. So rather than leaving that to chance, best to have these things sorted or at least contemplated in your estate planning to at least try to mitigate that risk, because it'll always, as long as they're eligible, they'll always remain eligible.
Yeah.
It's just a matter of, okay, well, what does that look like now in terms of any sort of further provision that they will be provided for from the estate.
That they might make a claim for. Okay.
Exactly.
This is via email, afternoons@4bc.com.au. Jeff from Red Bank Plains asks, are verbal claims, if witnessed or heard by another family member, admissible in a claim for an estate?
Yeah, it's a good question. You can bring these promissory estoppel claims where people can rely on things but then receive, there's a detriment to relying on these promises that were made.
Okay.
But that being said, it's a very hard line to get across. And these verbal promises, well, who's to say? Yes, there could be some other people too who can corroborate.
Yeah, they're in on it.
They're in on it. They can produce perhaps affidavit evidence to support the fact, well, I did hear these conversations, but to make sure it's set in stone and to make sure these wishes are properly reflected, your best point of call here is to make sure it's in writing and to make sure it's properly documented.
So in order to answer the question simply, I guess, it's very hard to prove a verbal agreement.
Correct.
And it's better just to get it done properly. Go and see the experts. Duncan MacDougall, Estate Litigation Senior Associate from Attwood Marshall Lawyers. I just find it so fascinating. Okay, very quickly, for families who might be listening now, who own a farm or a business and they want to kind of avoid these disputes, it's fair to say that a will is probably not just enough. What should they be doing?
Yeah. So people always say, well, I don't want to incur the costs of getting all this done as well, you know. But the reality is that down the track, if everything goes pear-shaped, you're going to be triple the cost as it's going to end up in terms of getting your estate done properly. So have that conversation with your estate planning lawyer. Have that conversation about how your assets are structured. Is there ways where you can perhaps change the dynamics of those assets, perhaps benefiting certain beneficiaries by other means rather than, for example, in the farm example, you've got, okay, the farm goes to this person, perhaps superannuation is split differently on a different end, life insurance, things like that. So my advice there is just get advice, get that proper estate planning done to avoid the costs that's going to eventuate down the track if things go.
That might be incurred.
Yeah.
Very quickly, Carol has texted in, good afternoon. Can I access a copy of my father's will who passed away several years ago?
Correct. Yes. As a child of the deceased, whether or not you're included or not, you will be entitled to receive a copy. So it generally, sometimes, unfortunately, it takes a solicitor's letter to request it because a lot of people don't, especially if an executor is unrepresented and trying to administer their estate themselves. Well, I'm not going to provide it to you. Well, they're legally obligated to provide it.
They have to.
They have to.
But you need to do it through a solicitor.
Sometimes that's what it takes.
Okay. All right. Interesting. All right. Well, thank you so much, Duncan MacDougall, for coming in, as always, imparting your knowledge on us. If you've got a question ahead of time and you'd like it answered next week, you can email us afternoons@4bc.com.au. Duncan MacDougall from Attwood Marshall Lawyers, thank you so much for dropping by like you do in the Legal Lowdown.